So this was a moment right before lunch today, right when the defense, Trump's defense lawyer, was ending his summation. So basically, the climax of Trump's final case to the jury. Judge Merchan seemed to get quite mad at Trump's defense counsel. Judge Merchan is not a man who is like easily ired. But what happened in front of the jury was an objection from the prosecutor at the end of Trump's closing statement. The prosecutor objected. Judge Merchan sustained the objection. But then the jury was sent out of the room. And what happened after the jury was out of the room was a thing. It was a notable confrontation. It was a notable admonition to Trump's lead defense counsel, and it led to the jury being told something sort of unexpected after they were brought back in after lunch. So it was kind of the big drama involving Judge Merchan of the day, and here's how it went. Todd Blanche, Trump defense counsel. I'm going to end this summation the same way I told you a few minutes ago, that you know you cannot rely on him, meaning Michael Cohen, which is that all those lies under oath, lies to his family, lies when it matters, lies when it doesn't matter, all those lies, put them aside for just a moment. That's alone enough to walk away. But then he came in here, again, meaning Michael Cohen, he raised his right hand and he lied to each of you repeatedly. You cannot send somebody to prison. You cannot convict somebody. Steinglass, the prosecutor, objection. Judge Merchan, sustained. Trump's defense counsel, Blanche, you cannot convict somebody based upon the words of Michael Cohen. So thank you for paying attention. I know it was a long morning and we went through a lot of evidence, but it's important. It's important to President Trump. It's important, of course, to his family. And I meant what I said in the beginning. It's clear that you all have been paying very close attention for the past 5 weeks, and that matters. That's very important. You know, this isn't a referendum on your views of President Trump. This is not a referendum on the ballot box, who you voted for in 2016, 2020, or who you plan on voting for in 2024. That's not what this is about. The verdict that you are going to reach has to do with the evidence you heard here in this courtroom and nothing else. Nothing else that you knew or thought about President Trump or about any of the other folks that testified, but just the evidence that you heard from the witnesses, the recordings, and the documents. If you do that, if you focus just on the evidence you heard in this courtroom, this is a very, very, very quick and easy not guilty verdict. Thank you. That is the conclusion of Donald Trump's case to the jury. And then Judge Merchan says, thank you, jurors. We're going to take our luncheon recess at this time. I'll see you at 2 p.m. Enjoy your lunch. The court officer, all rise. Everybody rises. Jury exits. And the judge says, after the jury's gone, the judge says, you may be seated, meaning nobody else is going anywhere, even though the jury is. And then Mr. Steinglass, the prosecutor, says, we would like a curative instruction for that ridiculous comment that Mr. Blanche made at the end of his summation about sending the defendant to prison. There is no requirement of prison. Punishment is something that's explicitly that the jurors are told not to consider. And that was a blatant and wholly inappropriate effort to cull sympathy for their client. Judge Merchan then says to Trump's defense counsel, let me hear your comment about prison. Todd Blanche, pardon? The judge, let me hear you about your comment about prison. Todd Blanche, I mean, Your Honor, there is already an instruction that you're going to give as part of the charge on that, and so we don't think there needs to be a curative instruction. Judge Merchan, I'm going to give a curative instruction. And then Judge Merchan says this, quote, I think that saying that was outrageous, Mr. Blanche. Please have a seat. For someone who has been a prosecutor as long as you have and a defense attorney as long as you have, you know that making a comment like that is highly inappropriate. It is simply not allowed, period. It is hard for me to imagine how that was accidental in any way. I will give a curative instruction. I will ask the people, meaning the prosecution, to draft one up, and I will give it. See you at 2 o'clock. Prosecutor, Mr. Steinglass, thank you. And then the luncheon recess is taken. Everybody goes away for lunch, and then this is what happens after lunch. The prosecutors now, so the defense has finished. They have stopped their case. This is it. They're done. Prosecutors are about to start their closing argument, and this is how it starts. The judge says, let's get the jury, please. The sergeant says, all rise, jury entering. The jury enters. Judge Merchan says, you may be seated. The clerk says, case on trial continued. All jurors are present and properly seated. And then the judge immediately says this, jurors, Before we hear the people's summation, there is an instruction that I wanted to give you. During the defense summation, you heard Mr. Blanche asking, in substance, that you not send the defendant to prison. That comment was improper, and you must disregard it. In your deliberations, you may not discuss, consider, or even speculate about matters relating to sentence or punishment. If there is a verdict of guilty, it will be my responsibility to impose an appropriate sentence. A prison sentence is not required for the charges in this case in the event of a guilty verdict. And then he says, people, meaning prosecution, it's time to get started. Mr. Steinglass, the prosecutor, says, thank you, Your Honor, counsel, and members of the jury. Good afternoon. What did Todd Blanche do so wrong that it evinced that at this crucial moment from Judge Merchan? Joining us now is former FBI General Counsel Andrew Weissmann. He was also at the courthouse today for today's closing arguments. Andrew, what happened there?
So this is totally taboo. You do not, and everyone knows, you do not raise, as Jen said, the issue of punishment. You do not raise the issue of going to jail. And I think one of the best ways to understand what's going on here is the reality of the fact that this is the former president of the United States. And what Todd Blanche was doing here, and then I'm going to turn for a moment to what Josh Steinglass did at the end of his summation, because I think they're rooted in the same way. I think that what's happening here is this was a way of trying to raise the burden on the state to really say to the jury, are you really sending this person to jail? The former president and maybe the future president of the United States. Totally improper argument. It is absolutely clear that the judge was right to give the curative instruction. One thing to note is it was so clear that the defense actually agreed, made no objection to the curative instruction that was given, the one that was drafted up that you just read. They were given an opportunity to object, and they didn't. And it's because, the bell was rung. The jury heard it. And frankly, even getting the curative instruction kind of again reinforces it. So the defense was really trying to raise the bar for the state. And the same way that I think that Josh Steinglass, in a way that was objectionable, but not sort of in the same category, where at the end of his summation, he was saying about Donald Trump, you know what? He cannot shoot somebody, as he has famously said, on Fifth Avenue and not be held to account. What he was getting at is the concern that the jury is going to hold the state to an even higher burden than beyond a reasonable doubt because he is the former president. And this was saying, you know what? He's just like everyone else. He's got to be held to the same standard of complying with the law. And so I think that's why you saw both lawyers trying to figure out a way to either play that to their advantage or to sort of raise the burden or to lower the burden to what it should be. So I think that's a real reality that's going on in the courtroom.
Andrew, can I just ask you about whether they're taking on a level of risk in doing so? As you say, in both of those cases, objections were sustained. In the first case, when the defense did it, there was the judge explicitly told the jury, basically right then and there, the next moment he was talking to them, do not consider what he just told you. That was wrong. You shouldn't have heard it. But in both cases, the bell was rung. The jury did hear it. When lawyers do things like that in the courtroom, are they taking a risk? I mean, it sort of seems like if you want the jury to hear those things, just being told, oh, you shouldn't have said that, having the jury said, oh, you shouldn't have heard that, kind of doesn't feel like enough of a fix, enough of a cure.
So the answer is yes, they are taking a risk. The best thing I've ever heard a judge do is actually Judge Dearie. The name may ring a bell because he was the special master in the Judge Cannon case, is when a lawyer did that the first time, he brought the lawyer over to the sidebar and said to him, with counsel only present, saying, you do that again, and I am going to cut your knees out from under you in front of the jury. Meaning, if you think there's no cost to you in terms of the effect of ringing that bell, there will be a cost. And because unfortunately, lawyers will do things like that. They're not supposed to. But sometimes, they take their sort of zealous advocacy too far. I do think it's worth noting that what Josh Steinglass did, while the objection was sustained, it is a very different category. I don't think it was likely to be, something that he was going to say I think he sort of suspected there would be an objection to be sustained, but it's not in the same category as talking about punishment, where everybody who is a prosecutor and defense lawyer knows that is absolutely off limits.
Andrew Weissmann, very, very helpful to have you on that. Thank you very much, my friend.